It's a 500-page book, and at the end it says, and so vote for X. The government could ban that. Take my hypothetical. It doesn't say at the outset. It runs here is a discussion of the American political system, and at the end it says vote for X.
Yes, our position would be that the corporation could be required to use PAC funds rather than general treasury
And if
funds.
they didn't, you could ban it.
If they didn't, we could prohibit the publication of the book.
Everything you think you know about Citizens United versus Federal Election Commission is wrong. Not kind of wrong. Not, well, it's complicated wrong. Completely, demonstrably, factually wrong. For 15 years, politicians, activists, and media outlets have been lying to you about what the case actually said. They've told you it declared corporations are people. It didn't. They've told you it created unlimited political spending. It didn't. They've told you it unleashed dark money. It did not. They've told you it created super PACs. It also did not do that. I'm going to spend the next hour and a half showing you exactly what Citizens United actually decided, line for line, word for word, straight from the opinion itself. We're going to read the actual text. We're going to look at what the court explicitly said and what explicitly did not say. We're going to trace the history of campaign finance law that led to this case. We're going to examine every single myth, distortion, and outright lie that's been told about this decision. And I'm going to show you the real impact, what actually changed, what stayed the same, and why almost everything you've been told about this case is propaganda. Citizens United did not come out of nowhere. It's the culmination of more than a century of fighting over campaign finance law. Allow me to walk you through key cases and statutes that built the framework. First is the 1907 Tillman Act. This was the first federal ban on corporate contributions. Teddy Roosevelt's 1904 campaign had been heavily funded by corporate donations such as Standard Oil, J.P. Morgan, E.H. Harriman. After he won, Roosevelt regretted it and pushed for reform. The Tillman Act banned corporations from making contributions to federal candidates. But that's the key part. It banned contributions, not independent expenditures. Corporations could still spend their own money on their own political speech. They just couldn't give it directly to candidates. Next was the Federal Corrupt Practices Act of 25. This required disclosure of campaign contributions and expenditures. However, it was weak and rarely enforced. Then, the 1947 Taft-Hartley Act. This extended the corporate contribution ban to labor unions. More importantly, it added a ban on expenditures, not just contributions. Section 304, quote, "It is unlawful for any national bank or any corporation organization by authority of any law of Congress to make a contribution or expenditure in connection with any election to any political office," end quote. For the first time, corporations and unions were banned from spending their own money on political speech. This law was barely enforced for decades, but it still set the precedent. Buckley v. Vallejo in 1976. This is the most important campaign finance case before Citizens United. Congress had passed the Federal Election Campaign Act, FECA, in 1971, and amended it in 1974 after Watergate. FECA imposed limits on contributions and expenditures. Senator James Buckley and others challenged the law as violating the First Amendment. The Supreme Court issued a complex per curiam opinion that did several things. Contribution limits upheld. The court said that limits on direct contributions to candidates are constitutional because they serve the government's interest in preventing corruption or the appearance of corruption. 2. Expenditure limits struck down. The court struck down limits on independent expenditures, saying, quote, "The First Amendment denies government the power to determine that spending to promote one's political views is wasteful, excessive, or unwise. In the free society ordained by our Constitution, it is not the government, but the people, individually as citizens and candidates, and collectively as associations and political committees, who must retain control over the quantity and range of debate on public issues in political campaign. End quote. This created a two-tiered system. Contributions can be limited, independent expenditures cannot. 3. Corporate and union bans were left in place. The court did not address whether corporations and unions could be banned from making independent expenditures. That question was left for later. Buckley's framework, contributions yes, expenditures no, would last for the next 34 years. FEC versus Massachusetts Citizens for Life. The Massachusetts Citizens for Life, or the MCFL, was a nonprofit anti-abortion group that wanted to spend money from its treasury on political ads. The FEC said no, you're a corporation, you're banned under FECA. The Supreme Court created an exception for certain nonprofits. If the corporation is 1. Formed for ideological purposes, not business purposes, 2. Has no shareholders, and 3. Doesn't accept corporation or union money, then it can't be banned from spending on independent expenditures. This created the MCFL exemption. Next is Austin versus Michigan Chamber of Commerce. The Michigan Chamber of Commerce wanted to run a newspaper ad supporting a candidate for state office. Michigan law banned corporate spending on candidate elections. The chamber argued this violated the First Amendment under MCFL. The Supreme Court, 6-3, upheld the ban. Justice Thurgood Marshall's majority opinion created the new rationale preventing the, quote, corrosive and distorting effects of immense aggregations of wealth, end quote. This was different from the anti-corruption rationale. This was saying corporations have too much money and that money will distort democracy. Justice Scalia dissented. Attention all citizens. To assure the fairness of elections by preventing disproportionate expression of the views of any single powerful group, your government has decided that the following associations of citizens and peoples shall be prohibited from speaking or writing in support of any candidate, end quote. He called it Orwellian. Austin became the precedent that allowed corporate spending bans. After the 2000 election, Congress passed the Bipartisan Campaign Reform Act of 2002, commonly known as McCain-Feingold. Its key provisions were that it banned soft money, unlimited contributions to parties, and banned corporation and union funding of electioneering communications within 30 days of primary elections and 60 days of general elections. An electioneering communication was any broadcast ad that 1. Refers to a clearly identified federal candidate, 2. Airs within 30 days of a primary or 60 days of a general, and 3. Is targeted to the candidate's electorate. Senator Mitch McConnell and others sued, arguing this violated the First Amendment. The Supreme Court, 5-4, upheld the most of McCain-Feingold, including the electioneering communications ban. Justice Stevens wrote the majority opinion, joined by O'Connor, Souter, Ginsburg, and Breyer. Justice Scalia, Kennedy, and Thomas all dissented, arguing the law was unconstitutional censorship. Next was FEC versus Wisconsin Right to Life. Wisconsin Right to Life, WRTL, was a pro-life group that wanted to run ads asking people to contact their senators about judicial filibusters. The ad said, "Contact Senators Feingold and Cole to tell them to oppose the filibuster." The FEC said, "That's electioneering communication. Senator Feingold is running for re-election. You cannot air this within 60 days of the election." WRTL sued. The Supreme Court, 5-4, ruled in favor of WRTL. Chief Justice Roberts' plurality opinion created an as-applied exception to McCain-Feingold. If an ad could be reasonably interpreted as something other than express advocacy or against a candidate, it can't be banned. This weakened it significantly. Justice Scalia, joined by Kennedy and Thomas, concurred, but said the court should just overturn Austin and McConnell outright. This full judicial restraint is judicial obfuscation. The most significant fact about WRTL's ads is that they provide no basis for banning them. End quote. This set the stage. By 2008, you had 1. Buckley saying independent expenditures by individuals cannot be limited. Austin saying corporate independent expenditures can be limited. McConnell saying electioneering communications by corporations and unions can be banned. And WRTL saying some electioneering communications can't be banned. It was a mess. Citizens United would force the court to reconcile all this. Now let's talk about what exactly happened in Citizens United versus FEC. Citizens United is a 501c4 nonprofit corporation. It was founded in 1988 by a guy named Floyd Brown, who became a famous, or infamous, for producing the Willie Horton ad in the 1988 presidential election. In 2008, Citizens United was a conservative advocacy group that produced documentaries, ran a news website, and engaged in political activism. In 2007, they produced a 90-minute documentary called Hillary, the Movie. Let me be very clear about what this film was. It was a hit piece. It was not balanced journalism. It was a critical documentary featuring interviews with conservative commentators like Ann Coulter, Dick Morris, and Newt Gingrich, all saying unflattering things about Hillary Clinton's record and character. This film completed in early 2008, right as the Democratic primaries were heating up. Citizens United wanted to do 3 things. 1. Air the film on cable TV via video on demand. 2. Run the TV ads in promotion of the film. And 3. Show the ads within 30 days of the primary elections. The problem? McCain-Feingold. Under the Bipartisan Campaign Reform Act, corporations couldn't use their general treasury funds to pay for electioneering communications within 30 days of a primary. The ads promoting the film clearly identified Hillary Clinton, a federal candidate. They would run within 30 days of a primary. Citizens United was a corporation. The Federal Election Commission said, "You can't do this. It violates the law." Citizens United could have A. Formed a separate PAC funded by voluntary contributions, B. Aired the ads outside of the 30-day window, or C. Not run ads at all and just distributed the film directly. But they didn't want to do any of those things. Instead, they sued, arguing that McCain-Feingold violated the First Amendment. The case went to U.S. District Court for the District of Columbia, a 3-judge panel that ruled against Citizens United, upholding the law under McConnell versus FEC. Citizens United directly appealed to the Supreme Court. This is where it gets interesting. The Supreme Court initially heard oral arguments in March 2009. During those arguments, the government's lawyer, Deputy Solicitor General Malcolm Stewart, was asked a hypothetical. Justice Alito asked, if a 401c3 corporation publishes a book that mentions a candidate for federal office, could the government ban the book within 30 days of an election? End quote. Stewart answered, yes, under our theory, the government could ban the book. The courtroom went silent. Chief Justice Roberts asked for clarification. Stewart doubled down. If a corporation published a book that was, quote, express advocacy or its functional equivalent, end quote, yes, the government could ban it under McCain-Feingold. The justices were stunned. After that argument, the court did something unusual. It ordered a re-argument. It asked the parties to brief and argue a much broader question. Should the court overrule Austin versus Michigan Chamber of Commerce and the part of McConnell that upheld McCain-Feingold's electioneering communications ban? This was no longer just about whether Hillary the movie could be aired. It was now about whether corporations had First Amendment rights to engage in independent political spending at all. This happened in September 2009. This time, Solicitor General Elena Kagan argued for the government. She tried to walk back Stewart's book banning answer, but the government had never tried to ban books and wouldn't. Justice Scalia was not having it. Quote, "You said in your brief that the government could ban books. We're supposed to just trust you not to?" On January 21st, 2010, the Supreme Court issued its decision. 5-4 in favor of Citizens United. Justice Kennedy wrote the majority opinion, joined by Chief Justice Roberts, Justices Scalia, Thomas, and Alito. Justice Stevens wrote a 90-page dissent, joined by Justices Ginsburg, Breyer, and Sotomayor. Now let's get into what the court actually said, because this is where the lies starts. I'm going to walk you through Justice Kennedy's majority opinion, section by section, quoting directly from the text. Because here's the thing. Most people who talk about Citizens United have never read it. They're relying on media summaries, political talking points, or Justice Stevens' dissent. Part 1. The First Amendment Framework. Kennedy starts with the foundational principle. Quote, "The First Amendment provides that Congress shall make no law abridging the freedom of speech. Laws enacted to control or suppress speech may operate at different points in the speech process." End quote. He then immediately addresses the government's central argument that corporate speech can be banned to prevent corruption. Quote, "Premised on the mistrust of government power, the First Amendment stands against attempts to disfavor certain subjects or viewpoints. Prohibited, too, are restrictions distinguishing among different speakers, allowing speech by some but not others." End quote. This is crucial. The government was arguing that we can ban corporate speech because corporations are different from individuals. Kennedy's response, "The First Amendment does not care who the speaker is. Speech is speech." He continues, quote, "If the First Amendment has any force, it prohibits Congress from fining or jailing citizens or associations of citizens for simply engaging in political speech." End quote. Notice the language, associations of citizens. This is the first place we see Kennedy's framework. He is not saying corporations are people. He is saying corporations are groups of people who've chosen to speak collectively. Part 2. Why Austin was wrong. The bulk of the opinion is dedicated to explaining why Austin versus Michigan Chamber of Commerce, the 1990 case that allowed corporate spending bans, was wrongly decided and should be overruled. Kennedy writes, quote, "Austin interferes with the open marketplace of ideas protected by the First Amendment. It permits the government to ban political speech simply because the speaker is an association that has taken on the corporate form." End quote. He then dismantles Austin's central rationale that the government can ban corporate speech to prevent, quote, "the corrosive and distorting effects of the immense aggregations of wealth," end quote. Kennedy quote, "If Austin were correct, the government could prohibit political speech of media corporations. Yet media corporations accumulate wealth with the help of corporate form. The largest media corporations have immense aggregations of wealth, and the views expressed by media corporations have had little or no correlation to the public support for these views. Thus, under the government's reasoning, wealthy media corporations could have their voices diminished, put them on par with other media entities. There is no precedent for permitting this under the First Amendment." End quote. This was devastating. The Kennedy is saying If the government can ban corporate political speech because corporations have too much money, then the government can ban the New York Times from endorsing candidates. The government never had a good answer for this. Kennedy continues, quote, "The censorship we now confront is vast in its reach. The government has muffled the voices that best represent the most significant segments of the economy, and the electorate has been deprived of information, knowledge, and opinion vital to its function." End quote. Part 3. The independent expenditure distinction. Kennedy then explains why independent expenditures are different from direct contributions. Quote, "Independent expenditures, including those made by corporations, do not give rise to corruption or appearance of corruption." End quote. Why not? Quote, "The absence of prearrangement coordination of an expenditure with the candidate or his agent alleviates the danger that expenditures will be given as a quid pro quo for improper commitments from the candidate." End quote. In other words, if I spend $1 million on ads supporting candidate X, but I never talk to candidate X or his campaign, there's no quid pro quo. The candidate can't promise me anything in exchange because he doesn't control spending. Kennedy quotes Buckley v. Vallejo, quote, "The independent expenditures ceiling fails to serve any substantial government interest in stemming the reality or appearance of corruption in the electoral process." End quote. This isn't new law. This is applying a principle the court established in 1976. Part 4. Associations of citizens. This is where Kennedy explains his corporations are associations theory. Quote, "The court has recognized the First Amendment protection extends to corporations. This protection has been extended by explicitly holding to the context of political speech." End quote. He cites multiple precedents. First National Bank of Boston versus Belletti in 1978. Corporate speech on ballot initiatives is protected. The NAACP versus Button in 1963. Associational rights are protected. New York Times versus Sullivan in 1964. Media corporations have First Amendment rights. Then he drives home the point. Quote, "Political speech is indispensable to the decision-making of a democracy, and this is no less true because the speech comes from a corporation rather than an individual." End quote. And, quote, "The First Amendment does not permit Congress to make categorical distinctions based on the corporate identity of the speaker and the content of the political speech." End quote. Part 5. What about media corporations? The government tried to argue that media corporations are different and should be exempted. Kennedy destroys this. Quote, "The media exemption discloses further difficulties with the law now under consideration. There is no precedent supporting laws that attempt to distinguish between corporations which are deemed to be exempt as media corporations and those which are not." End quote. And then his kill shot, quote, "We have consistently rejected the proposition that the institutional press has any constitutional privileges beyond that of other speakers." End quote. In other words, the New York Times doesn't get special First Amendment privileges or rights that ExxonMobil doesn't get. Either corporation speech is protected or it is not. Part 6. Shareholder protection is not a compelling interest. The government also argued, quote, "We need to ban corporate political speech to protect shareholders who might disagree with the corporation's political views." Kennedy's response, quote, "If Congress had been seeking to protect dissenting shareholders, it would not have banned corporate speech in only certain media within 60 or 30 days before an election. A dissenting shareholder's interest would be implicated by speech in media at any time." End quote. Translation: This argument is pretextual. If you really cared about dissenting shareholders, you'd ban all corporate political speech, not just speech before elections. Part 7. Overruling Austin and McConnell. Kennedy concludes, due consideration leads to this conclusion. Austin should be and now is overruled. We return to the principle established in Buckley and Belletti that the government may not suppress political speech on the basis of speaker's corporate identity. No sufficient governmental interest justifies limits on political speech for nonprofit or for-profit corporations. End quote. And, quote, when government seeks to use its full power, including the criminal law, to command where a person may get his or her information or what is distrusted source he or she may not hear. It uses censorship to control thought. This is unlawful. The First Amendment confirms the freedom to think for ourselves." End quote. That's the core of the majority opinion. Now let's talk about what the court explicitly did not do. The Citizens United majority opinion is 57 pages long. Justice Stevens' dissent is 90. The entire decision with concurrences is 183 pages. The first myth. Citizens United said corporations are people. Let's do a simple test. I'm going to search the entire 183-page PDF for the phrase corporations are people. Results? 0. Not once. Not in the majority, not in the current concurrences, not even in the dissent. The phrase corporations are people does not appear anywhere in the Citizens United versus FEC. So where does it come from? 2 places. First, Mitt Romney, August 11th, 2011. A year and a half after the decision, Romney was at an Iowa State fair and someone yelled about corporate taxes. Romney responded, quote, "Corporations are people, my friend," unquote. The media went crazy, frankly. Suddenly the quote, completely out of context, not even about Citizens United, became what the Supreme Court said. But Romney wasn't citing the case. He was making a point about how corporate taxes ultimately affect shareholders, citizens, employees, and customers, all real people. Whether you agree with that point or not, it has nothing to do with the Citizens United. Second, the dissent and political rhetoric. Justice Stevens' dissent repeatedly accused the majority of treating corporations like, quote, "natural persons," unquote. Critics of the decision loved that framing and amplified it. But here's what Kennedy actually wrote. Quote, "The court has recognized that First Amendment protections extend to corporations," unquote. That's not the same thing as saying corporations are people. It's saying the First Amendment protects speech regardless of who is speaking. Kennedy explicitly treats corporations as associations of citizens. Quote, "If the First Amendment has any force, it prohibits Congress from fining or jailing citizens or associations of citizens for simply engaging in political speech," end quote, and, quote, "corporations and other associations, like individuals, contribute to the discussion, debate, and dissemination of information and ideas that the First Amendment seeks to foster." Kennedy is saying that when citizens form an association, whether it's the ACLU, the NRA, the Sierra Club, or General Electric, they don't lose their First Amendment rights. The alternative would be absurd. You have free speech rights as an individual, but the moment you join with others to amplify your voice, the government can silence you. That's what McCain-Feingold did, and that's what the court struck down. Myth 2. Citizens United removed all limits on money in politics. This is probably the most pervasive lie. Let's be very, very clear about what the Citizens United did and did not do to campaign finance limits. What it struck down. First, the ban on corporations and unions using general treasury funds for independent expenditures. 2, the ban on corporations and unions funding electioneering communications within 30 or 60 days of elections. What CU explicitly preserved? Direct contribution limits. Kennedy writes, quote, "Citizens United has not made direct contributions to candidates, and it has not suggested that the court should reconsider whether contribution limits should be subjected to rigorous First Amendment scrutiny." Translation, the court is not touching contribution limits. Those stay in place. Coordination rules. The opinion repeatedly emphasizes that this only applies to independent expenditures. Quote, "Independent expenditures do not lead to or create the appearance of quid pro quo corruption. In fact, there is only scant evidence that independent expenditures even ingratiate." End quote. If you coordinate with a candidate, your spending counts as a contribution and is subject to all the existing limits. Disclosure requirements. This is a big one. The court upheld disclosure by an 8-1 vote. Kennedy writes, quote, "The First Amendment protects political speech, and disclosure permits citizens and shareholders to react to the speech of corporate entities in a proper way. This transparency enables the electorate to make informed decisions and give proper weight to different speakers and messages, end quote. Only Justice Thomas dissented on disclosure, arguing it could lead to harassment of donors. So after Citizens United, 1. Individuals can still only contribute $3,300 per election to a federal candidate. Corporations and unions still cannot contribute anything to federal election candidates. All political spending over $200 must be disclosed to the FEC, and coordination with campaigns is still prohibited and converts spending into contributions. The idea that Citizens United created unlimited money in politics is false. It created unlimited independent spending. Huge difference. Myth 3. Citizens United created super PACs. No, a completely different case did that. Citizens United came down on January 21st, 2010. On March 26, 2010, 2 months later, the DC Circuit Court of Appeals decided SpeechNow.org versus FEC. Here's what SpeechNow did. SpeechNow.org was a group that wanted to raise money for independent expenditures supporting libertarian candidates. They argued contribution limits to their organizations was unconstitutional. The DC Circuit agreed, reasoning, quote, in light of the court's holding as a matter of law that independent expenditures do not corrupt or create the appearance of quid pro quo corruption, contributions to groups that only make independent expenditures also cannot corrupt or create the appearance of corruption, end quote. Translation, if independent spending doesn't corrupt, then giving money to groups that only do independent spending can't corrupt either. Therefore, contribution limits to independent expenditure-only groups are unconstitutional. Those are super PACs. Before SpeechNow, you could only give $5,000 a year to a PAC. After SpeechNow, you could give $5 million to a super PAC as long as the super PAC never coordinates with candidates and only does independent expenditures. So the timeline is Citizens United, January 2010. Corporations and unions can spend unlimited amounts from their treasuries on independent political speech. SpeechNow, March 2010. Anyone, individuals, corporations, and unions can contribute unlimited amounts to groups that only do independent spending. Both cases working together created the modern super PAC landscape, but blaming Citizens United alone for super PACs is like blaming the invention of the wheel for drunk driving accidents. Myth 4. Citizens United unleashed dark money. Dark money usually refers to political spending by groups that don't have to disclose their donors, usually 501c4 nonprofits. People blame Citizens United for this constantly, but dark money groups existed and were spending hundreds of millions long before 2010. Let me give you some specific examples. Swift Boat Veterans for Truth in 2004. 527 organization spent $22.6 million attacking John Kerry. Donors included Texas home builder Bob Perry, $4.4 million, and others, but full donors weren't listed. America Coming Together, 2004. Spent $76 million on voter mobilization, funded by George Soros and others, and limited disclosure requirements. Club for Growth, 2000s. 501c4 nonprofits spent tens of millions on ads and did not disclose donors. American Crossroads and Crossroads GPS, founded in 2010 by Karl Rove. Crossroads filed as a 501c4 in September 2009, 4 months before Citizens United. The legal framework for 501c4s is in the IRS code and has been there since 1959. These groups have always been allowed to do some political activity without disclosing donors. What Citizens United did was uphold disclosure requirements for electioneering communications. Here's Kennedy's full quote on disclosure. Disclaimer and disclosure requirements may burden the ability of some speakers to present their message in time and manner of their choosing, but they impose no ceiling on campaign-related activities and do not prevent anyone from speaking. The court has subjected these requirements to exacting scrutiny, which requires a substantial relation between the disclosure and requirement and sufficiently important governmental interests, unquote. And, quote, with the advent of the internet, Prompt disclosure of expenditures can now provide shareholders and citizens with the information needed to hold corporations and elected officials accountable for their positions and supporters. Shareholders can determine whether their corporation's political speech advances the corporation's interest in making profit, and citizens can see whether the elected officials are in their pocket, quote unquote, of so-called moneyed interests, end quote. The 8-1 vote on disclosure is one of the most overlooked aspects of Citizens United. The court explicitly preserved the tools for transparency. So why did 501c4 spending explode after 2010? Not because of Citizens United directly, but because political operatives realized they could route money through nonprofits to hide donors while still doing independent spending. That's a loophole in the IRS code, not something to do with something Citizens United created. If you want to close the loophole, you need to change the tax code, not overturn Citizens United. Justice John Paul Stevens wrote a 90-page dissent in Citizens United. It's passionate, it's eloquent, it's also the losing side. But the dissent became the narrative. Media outlets quoted it extensively, politicians cited it, and activists made it protest signs from it. So we need to understand what and why Stevens argued and why the majority rejected it. Stevens' core arguments. First, corporations aren't people. Stevens writes, quote, in the context of election to public office, the distinction between corporate and human speakers is significant. Although they make enormous contributions to our society, corporations are not actually members of it. They can neither vote nor run for office, end quote. He continues, quote, the financial resources, legal structure, instrumental orientation of corporations raise legitimate concerns about their role in the electoral process, end quote. Stevens is making a moral and democratic argument. Corporations are citizens, so they shouldn't have the same speech rights as citizens. Kennedy's response from the majority. First Amendment doesn't say Congress shall make no law abridging the freedom of citizens. It says freedom of speech, period. Kennedy writes, the court has recognized the First Amendment protection extends to the corporations. This protection has been extended by explicit holdings to the context of political speech, and we find no basis for the proportionality or proposition that in the context of political speech, the government may impose restrictions on certain disfavored speakers. His second argument, corporate wealth will distort democracy. Stevens argued that unlimited corporate spending will drown out the voices of ordinary citizens. Austin recognized the coercive and distorting effects of immense aggregations of wealth that are accumulated with the help of the corporate form and that have little or no correlation to the public support for the corporation's political ideas. End quote. This is the distortion rationale from Austin. Kennedy's response was, quote, if Austin was correct, the government could prohibit political speech of media corporations, yet media corporations accumulate wealth with the help of the corporate form. The largest media corporations have immense aggregations of wealth, and the views expressed by media corporations often have little or no correlation to the public support for those views, end quote. Kennedy said if too much money is a reason to ban speech, then the New York Times, Fox News, and CNN can all be silenced. He also makes this point, quote, the rule of the political speech cannot be limited based on the speaker's wealth is a necessary consequence of the premise that the First Amendment generally prohibits the suppression of political speech based on the speaker's entity, end quote. 3. This will open the floodgates. Stevens warns, quote, a democracy cannot function effectively with its constituent members believe the laws are being bought and sold, end quote. He predicts this decision will lead to massive corruption and public cynicism. Kennedy's response, quote, the appearance of influence or access, furthermore, will not cause the electorate to lose faith in our democracy. Members of the public understand that the candidate is complying with the First Amendment, not a quid pro quo agreement, end quote. Essentially, voters aren't stupid. They can distinguish this corporation ran ads supporting this senator and This corporation owns the senator. 4. Stare decisis. Don't overturn precedent. Stevens dedicates 30 pages to arguing that the court shouldn't have overturned Austin and McConnell. He writes, the only relevant thing that has changed since Austin and McConnell is the composition of this court. Translation, you're overturning precedent just because you have 5 conservative votes now. Kennedy responds, quote, this court has not hesitated to overrule decisions offensive to the First Amendment. Austin is undermined by the experience since its announcement. Political speech is so ingrained in our culture that speakers find ways to circumvent campaign finance laws, end quote, and, quote, continued adherence to Austin amounts to unprecedented breach of the judicial restraint that courts must observe, end quote. Bottom line for the dissent, Stevens' dissent is powerful rhetoric. It's emotionally compelling. It paints a picture of democracy being sold to the highest bidder. But it's not the law. The majority rejected every one of his arguments. And here's the thing. The dissent's warnings became the popular understanding of what Citizens United did, even though they were predictions about what it might do. Corporations will buy elections. Democracy will die. Billionaires will control everything. These were Stevens' concerns, not the holding of the case. But because the dissent was so widely quoted, millions of people think Stevens' predictions were the court's rulings. That's how misinformation works. The oral arguments in Citizens United were some of the most dramatic in Supreme Court history. There were 2 rounds, March 2009 and September 2009. Let me walk you through the key exchanges. The first argument, March 24th, 2009, Theodore Olson argued for Citizens United. He was one of the most respected Supreme Court advocates in his day. He argued 60-plus cases before the court. Olson's argument was straightforward. Hillary the movie is protected political speech. McCain-Feingold's ban on electioneering communications violates the First Amendment. The government's lawyer was Deputy Solicitor General Malcolm Stewart. And this is where it went off the rails. The book banning exchange. Justice Alito asked a hypothetical. Alito, if a 501c3 corporation publishes a book and the book mentions a candidate for federal office, could the government ban that book under your theory? Stewart, if the book contained express advocacy, yes. The government could prohibit the publication of the book using corporate treasury funds. Chief Justice Roberts jumped in. Roberts, I'm sorry, the government could ban a book? Stewart, if it's express advocacy, yes. Although I should note the government has never tried to ban a book. Kennedy, but you think the government could? Stewart, under our current theory, yes. Justice Kennedy was horrified. The problem for the government, Stewart had to defend this position because McCain-Feingold's logic, corporations can be banned from funding communications that support or oppose candidates, applied to books just as much as TV ads. If you concede that books are exempt, then what's the limiting principle? Why can you ban a 90-minute documentary but not a 300-page book? Both are political speech. Stewart tried to walk it back. Stewart, we've never tried to ban books and we don't think that would be appropriate. Scalia, that's not the question. You're telling us the statute would allow it. Stewart, I'm saying the statute, as written, might allow it, but we would never use that authority. Kennedy, so we're just supposed to trust you? The exchange, the government admitting it could ban books, completely shifted the case. After oral arguments, the justices conferred. Instead of issuing a narrow decision on whether Hillary the movie could be aired, they decided to go bigger. On June 29, 2009, the court issued an order for a supplemental briefing on the question, should the court overturn Austin v. Michigan Chamber of Commerce and the part of McConnell versus FEC, which addresses the facial validity of Section 203 of the Bipartisan Campaign Reform Act of 2002. Translation, we're thinking of blowing up 20 years of precedent. Brief that. This was huge. The court was signaling it might overturn Austin and McConnell entirely. The second argument, September 9th, 2009. This time, Solicitor General Elena Kagan argued for the government. She'd just been nominated by Obama and was trying to clean up Stewart's mess. Exchange on books. Roberts, last time your colleague said the government could ban books. Is that still the government's position? Kagan, the government's answer has changed. The government's answer is that it could not ban books. Scalia, that's lovely. But you said in your brief that the government could ban books published by corporations. Were you lying in the brief? Kagan, no, Justice Scalia. We were addressing the statute as written, but we don't think that statute should apply to books. Scalia, you're asking us to uphold a statute that you admit could be used to ban books, and you're just promising you won't use it that way? Kagan, we think the court could create an as-applied exception for books. Kennedy, so now we're supposed to create a media exemption? Kagan, the court has long recognized that different media has different characteristics. Roberts, okay, what about pamphlets? A corporation can't publish a pamphlet? Kagan, a pamphlet would be different from a full-length book, yes. Scalia, could they publish it on the internet? Kagan, we think that statute should be read narrowly. Kennedy, that's not an answer. The government was in an impossible position. If they said the corporations can't publish books, they'd be defending censorship. Kagan tried to thread the needle. Quote, the statute should be read narrowly and we'd never ban books, end quote. The justices weren't buying it. The exchange on newspapers. Kennedy, why isn't the New York Times a corporation? Kagan, the New York Times is a media corporation. Congress has traditionally exempted single media corporations from these restrictions. End quote. Scalia, why? What's the constitutional basis for saying the New York Times Corporation has more First Amendment rights than, say, a book publisher? Kagan, the press plays a unique role in our democracy. Roberts, but corporations own most major newspapers. If immense aggregations of wealth are the problem, why aren't newspapers banned from endorsing candidates? Kagan, the institutional press is different. Scalia, I don't see that in the First Amendment. Congress shall make no law except for non-media corporations? Kagan had no good answer. The oral arguments made it clear. If the government's theory was correct, Congress could ban the New York Times, Simon & Schuster, Random House, and every other corporate publisher from participating in elections. This was untenable. After the second argument, it was clear which way the court was leaning. To understand why Citizens United came out the way it did, you need to understand the Supreme Court's First Amendment jurisprudence. The court has spent 100+ years developing a framework for when the government can and cannot restrict speech. Allow me to walk you through these key principles. First, content-based versus content-neutral restrictions. If the government restricts speech based on its content, what's being said, that triggers strict scrutiny. Strict scrutiny means the government must prove it has a compelling interest, not just important, but compelling. The law is narrowly tailored to serve that interest, and there's no less restrict alternative. Content restrictions almost always get struck down. If the restriction is content neutral, it restricts the time, place, or manner of speech regardless of what's being said. That's subject to intermediate scrutiny, which is much easier to satisfy. Example, you can't protest abortion would be content-based, strict scrutiny, almost certainly unconstitutional. Or another one would be, you can't use a loudspeaker after 10 p.m., content-neutral, immediate scrutiny, probably constitutional. McCain-Feingold was content-based. It banned speech based on what was being said, mention of a candidate, and who was saying it. This triggers strict scrutiny. Second, speaker-based restrictions. The Supreme Court has repeatedly held that the government generally cannot restrict speech based on who is speaking. Key cases would be First National Bank of Boston versus Belletti in 1978. Massachusetts banned corporations from spending money on ballot initiative campaigns. The court struck it down saying, quote, the inherent worth of the speech in terms of its capacity for informing the public does not depend upon the identity of the source whether corporation, association, union, or individual, end quote. Consolidated Edison Company versus Public Service Commission, 1980. New York banned utility companies from including inserts about nuclear power in its bills. The court struck it down. Quote, the First Amendment's hostility to content-based regulations extend not only to restrictions on particular viewpoints, but also to prohibition of public discussion of an entire topic, end quote. Pacific Gas and Electric Company versus Public Utilities Commission, 1986. California required a utility to include message from a consumer group in its billing envelopes. The court said this violated the First Amendment. The identity of the speaker is not decisive in determining whether speech is protected. Corporations and other associations, like individuals, contribute to the discussion, debate, and dissemination of information and ideas that the First Amendment seeks to foster. McCain-Feingold explicitly restricted speech based on the speaker being a corporation. That's facially unconstitutional under decades of precedent. 3. Political speech gets the highest protection. The Supreme Court always said that political speech about candidates, election, and public issues, is the most protected category of speech. From Buckley v. Vallejo, quote, discussion of public ideas and debate on the qualifications of candidates are integral to the operation and system of government established by our Constitution, end quote. From McConnell, the case that Citizens United overruled, even Justice Stevens, writing for the McConnell majority, admitted, quote, political speech is indispensable to the decision-making of a democracy, end quote. McCain-Feingold didn't ban commercial speech or obscenity or defamation. It banned core political speech about the federal candidates during election season. That's the speech the First Amendment was designed to protect. 4. The government can't ban speech to level the playing field. The government argued in Citizens United that corporate spending bans are necessary to prevent wealth interests from drowning out ordinary citizens. The Supreme Court rejected that argument for 40 more years. From Buckley, quote, the concept that government may restrict speech of some elements of our society in order to enhance the relative voice of others is wholly foreign to the First Amendment. Translation, the government can't silence person A just because person B doesn't have as much money to speak. If that were allowed, the government could ban the New York Times for endorsing candidates because it has more reach than a small-town newspaper, ban cable news from covering campaigns because not everyone has cable, ban political books because not everyone could afford them. The leveling the playing field argument is a direct attack on the core principle of the First Amendment. More speech is always better than less speech. 5. Overbreadth and vagueness. Laws that restrict speech are often struck down because they're overbroad, cover way more speech than necessary, or vague. People can't tell what's banned. McCain-Feingold was both. Overbroad. It banned all electioneering communications by all corporations, including nonprofits like the ACLU or NRA, small, closely held corporations, and corporations that don't even have shareholders. Vague. The definition of electioneering communication was so unclear that groups couldn't tell if their speech was legal. Wisconsin Right to Life in 2007 found that the law was so vague it unconstitutionally chilled speech. The First Amendment Framework Summary. Political speech gets the highest protection. Content-based restrictions trigger strict scrutiny. Speaker-based restrictions are presumed unconstitutional. The government can't ban speech to level the playing field, and overbroad and vague laws get struck down. McCain-Feingold violated all 5 of these principles. That's why Citizens United came out the way it did. It wasn't just 5 conservative justices being pro-corporate. It is 5 justices applying 100 years of First Amendment doctrine. Now let's talk about corporate personhood, because this is where the most of the confusion and misinformation lies. When people say corporations are people, they're usually making one of 2 claims. Claim 1. Corporations are literally human beings and should be treated identically to natural persons. Claim 2. Corporations have some legal rights similar to how natural persons have legal rights. nobody that's serious, including the Supreme Court, has ever argued Claim 1. Citizens United argued Claim 2. Let me explain what corporate personhood actually means in the law. Legal Personhood 101. In a law, a person is any entity that can own property, enter into contracts, sue, and be sued. Under this definition, corporations have been persons since at least the 19th century, and no one disputes this. Why? Because it would be impossible for corporations to function otherwise. If a corporation couldn't own property, General Motors couldn't own factories. If a corporation couldn't enter into contracts, Apple couldn't hire employees. If a corporation couldn't be sued, Exxon couldn't be held liable for the Valdez oil spill. So when people scream corporations aren't people, they're either ignorant of what legal personhood means, or deliberately conflating legal personhood with biological personhood. Constitutional rights for corporations. Corporations don't have all constitutional rights, but have some. Rights corporations do have. Fourth Amendment, protection against unreasonable searches and seizures. Marshall v. Barlow Incorporated, 1978. OSHA cannot search a business without a warrant. Fifth Amendment, protection against takings without compensation. Corporations can have their top property taken by eminent domain without just compensation. Seventh Amendment, right to jury trials in civil cases. Corporations can demand a jury trial. First Amendment, freedom of speech and press. New York Times v. Sullivan, 1964. Media corporations have speech rights. First National Bank versus Belletti, 1978. Corporations have speech rights in ballot initiative campaigns. Rights corporations do not have. Fifth Amendment privilege against self-incrimination. Hale versus Henkel in 1906. Corporations cannot invoke the Fifth Amendment to refuse to produce documents. Right to vote. Corporations can't vote in elections, obviously. Right to run for office. Corporations can't be candidates, obviously. So corporate personhood is selective. Corporations can get some constitutional protections, not all. The Citizens United question wasn't, are corporations people? It was, do corporations have First Amendment rights to engage in political speech? And the answer, based on 100 years of precedent, was yes. Not because corporations are people, but because the First Amendment doesn't restrict who can speak. The text says, Congress shall make no law abridging the freedom of speech. It doesn't say freedom of speech for natural persons only. Kennedy wrote, the First Amendment does not permit Congress to make categorical distinctions based on the identity of the speaker. 2. Corporations are associations of people. When you ban corporate speech, you're not silencing some abstract entity. You're silencing the people who came up the corporation. Shareholders, employees, directors, all real people who've chosen to pool resources and speak collectively. Quote from Kennedy, if the First Amendment has any force, it prohibits Congress from fining or jailing citizens or associations of citizens for simply engaging in political speech. End quote. 3. The First Amendment protects the listeners, not just the speakers. Even if you think corporations shouldn't speak, what about the voters who want to hear what corporations have to say? The First Amendment includes a right to receive information. Kennedy. The government may also violate the First Amendment when it seeks to impose regulations on the marketplace of ideas. End quote. The media corporation problem. Here's the question that destroys the corporations aren't people argument. Should the New York Times be allowed to endorse candidates? Most people say yes. But the New York Times is a corporation. It's the New York Times Company, a publicly traded corporation with shareholders. If corporations don't have First Amendment rights, then the New York Times can be banned from endorsing candidates. Same with the Washington Post, CNN, Fox News, and more. In oral arguments, the government tried to create a media exemption. Media corporations get First Amendment rights, but other corporations don't. The justices tore this apart. Roberts. What constitutional basis for treating the New York Times Company different from General Motors? Scalia. I don't see anything in the First Amendment that says freedom of the press except for non-media corporations. There is no principled way to give the New York Times First Amendment rights but deny them to Citizens United, the ACLU, or even for-profit corporations. The association argument. This is the key to understanding Citizens United. Justice Kennedy doesn't argue that corporations are people. He argues that corporations are associations of people, and the right to associate, to pool your resources and speak together, is also protected by the First Amendment. From NAACP versus Button, 1963, quote, "A state may not, under the guise of prohibiting professional misconduct, ignore constitutional rights. Broad rules framed to strike at conduct that is inimical to the public welfare may easily become a weapon to suppress the freedoms of association and expression," end quote. From NAACP versus Alabama, 1958, effective advocacy of both public and private points of view, particularly controversial ones, is undeniably enhanced by group association, end quote. The NAACP is a corporation. The ACLU is a corporation. The NRA is a corporation. Greenpeace is a corporation. Planned Parenthood is a corporation. If corporations don't have First Amendment rights, all of these groups can be silenced. The bottom line in corporate personhood, Citizens United did not say corporations are people. It said associations of people don't lose their First Amendment rights just because they've incorporated. That's a huge difference. And it's a difference that everyone who criticizes the decision deliberately ignores. So what actually happened after Citizens United? Let's go ahead and look at the data, not the rhetoric, not the fear-mongering, but the actual empirical evidence. Outside spending exploded. This is undeniable. Before Citizens United 2008 election, total outside spending, not candidates or parties, was about $143 million. After Citizens United, 2010 midterms, $309 million. 2012, $104 billion. 2014, $560 million. 2016, $1.4 billion. 2018, $1.6 billion. 2020, $3.1 billion. 2022, $1.7 billion. That's a massive increase, but context matters. A, it's not just corporate money. The biggest Super PAC donors are individuals, not corporations. Sheldon Adelson, an individual, $218 million in 2020. Michael Bloomberg, an individual, $150 million in 2020. Tom Steyer, an individual, $67 million in 2020. Corporate contributions to PACs are actually relatively small compared to individual mega donors. B. Labor unions benefited too. From 2010 to 2011, labor unions spent over $1.1 billion on independent expenditures. Major union-backed super PACs would be Workers' Voice PAC, Patriot Majority USA, American Brigade 21st Century. This wasn't a one-sided corporate domination. Both sides are using the same tools. C. Disclosure still works. We know all of this spending is happening because the groups have to disclose it to the FEC. You can go to opensecrets.org right now and see every major expenditure. 2. Super PACs became dominant. Before 2010, no super PACs existed. After Speech Now in March of 2010, the floodgates opened. By the 2012 cycle, 1,310 super PACs were registered. $828 million was raised, and $609 million was spent. Major super PACs include Restore Our Future, pro-Romney, $153 million, Priorities USA Action, pro-Obama, $79 million, American Crossroads, Republican, $175 million. 3. Candidate-specific super PACs. Almost every major candidate now has an affiliated super PAC that operates independently, and here's how it works. Candidates can't legally coordinate with the super PAC, but the candidate's former staffers run the super PAC. The super PAC airs ads supporting the candidate. Mega donors give millions to the super PAC. The candidate and the super PAC somehow never coordinate, but always seems to be on the same page. This is the coordination loophole. a law that says you can't coordinate, but in practice, there's coordination through shared consultants, public statements, and watching each other's ads. Nobody's been prosecuted for this because it's almost impossible to prove. 4. Dark money did increase, but not because of Citizens United directly. 501c4 social welfare organizations don't have to disclose donors. Spending by these groups: 2006, 5.8 million, 2010, 95 million, 2012, 257, and 2020, 666 million. But remember, 501c4s existed before Citizens United. What changed after 2010 was political operatives realized they could route money through 501c4s to hide donors. The FEC didn't aggressively enforce disclosure rules, and the IRS didn't crack down on groups abusing the social welfare designation. That's not Citizens United's fault. That's the government failing. 5. Did money buy elections? Here's the question everyone asks. Did unlimited spending let billionaires buy elections? Here's some evidence against it. Jeb Bush in 2016 dropped $150 million, including $103 million from his super PAC, Right to Rise, and dropped out after winning 0 states. Tom Steyer in 2020 spent $253 million of his own money and won 0 delegates. Michael Bloomberg in 2020 spent over $1 billion and won American Samoa. Meg Whitman in 2010, California governor, spent $144 million of her own money and lost. Linda McCon in 2010 and 2012 Connecticut Senate race spent $100 million of her own money across 2 races and lost both. But there's some evidence for, which would be, money doesn't guarantee victory, but it helps. There's overwhelming financial advantage, usually wins. Incumbents with massive fundraising advantages almost always win. In open Senate races, the bigger spender wins about 80% of the time. The nuance is money is necessary, but it's not sufficient. You need to compete, but money alone doesn't win. You also need a good candidate, a good message, a good ground game, and a favorable political environment. Did corporate spending dominate? No. Despite the fears, direct corporate spending on independent expenditures has been relatively modest. Why? Reputational risk. Most corporations don't want the backlash from customers who disagree with their political spending. For example, Target donated $150,000 to a PAC supporting Minnesota gubernatorial candidate who opposed same-sex marriage. There was a massive boycott that ensued. Target apologized and pulled back. Massive corporations stay out of direct political spending for this reason. Instead, corporate money flows through trade associations, U.S. Chamber of Commerce and business roundtables, 501c4s, and individual donations from executives. 7. Polarization and negative ads. Negative advertising has increased since 2010. Super PACs can run attack ads while candidate stays above the fray. For example, candidate, I want to talk about the issues and bring people together. Candidate Super PAC, my opponent is a corrupt socialist who hates America. This has arguably increased polarization and negativity in campaigns. So the full impact would be something along the lines of outside spending exploded, but not just from corporations. Super PACs became a major force, speech now included, not just Citizens United. Dark money increased, but that's an IRS FEC problem, not Citizens United's fault. Money didn't buy elections outright, though it helps. Both parties use the same tools, and disclosure still works for most spending. Was Citizens United good or bad for democracy? That's a normative question, not a factual one. But the factual reality is much more complicated than the corporations bought America. Let's go through every major myth about Citizens United one more time with the receipts. Myth 1. Citizens United said corporations are people. The reality is the phrase corporations are people never appears in the 183-page decision. What Kennedy actually wrote, citizens are associations of citizens. The First Amendment protects speech and the speaker, and the ideas that flow from each. Corporations and others, associations like individuals, contribute to the discussion, debate, and dissemination of information and ideas. He treats corporations as associations of people, not people in and of themselves. The corporations are people line came from Mitt Romney 2011, and critics were misrepresenting the decision. Myth 2. Citizens United created super PACs. The reality is Speech Now versus FEC in March 2010 created super PACs, not Citizens United, January 2010. Citizens United corporations and unions can spend money on independent expenditures, and Speech Now is anyone can give unlimited to independent expenditure only groups. Super PACs are the result of both cases. Myth 3. Citizens United removed all limits on money in politics. The reality is contribution limits are still in place. Individuals can spend $3,300 per election, and corporations and unions are still completely banned. Coordination rules still apply. Only independent spending is unlimited. Myth 4. Citizens United unleashed dark money. The reality is dark money groups, 501c4s, existed long before 2010. Swift Vote Veterans 2004, $22.6 million. American Coming Together 2004, $76 million. Citizens United upheld disclosure requirements 8-1. Dark money increased after 2010 due to weak FEC enforcement, IRS rules allowing 501c4s to hide donors, and political operatives exploiting loopholes. That's not Citizens United's fault. Myth 5. Citizens United allows foreign corporations to spend in the U.S. elections. Reality. Completely false. Foreign nationals and foreign corporations are banned from spending in the U.S. elections under 52 U.S.C. number 30121. Citizens United never touched that law. Kennedy explicitly wrote, quote, "We need not reach the question whether the government has a compelling interest in preventing foreign individuals or associations from influencing our nation's political process." Translation: foreign spending wasn't part of this case and remains banned. Myth 6. Citizens United overturned 100 years of precedent. The Tillman Act in 1907 banned corporate contributions, but not independent expenditures. The Taft-Hartley Act of 1947 banned corporate and union expenditures, but were still rarely enforced until the 1970s. Austin 1990 was only 20 years old when it was overruled, and Austin itself was a break from prior precedent in Buckley and Belletti. Citizens United restored the Buckley framework and did not destroy it. Myth 7. The only people who support Citizens United are corporate shills. The reality is that organizations that filed amicus briefs supporting Citizens United were the ACLU, the Cato Institute, the Institute for Justice, the Center for Competitive Politics, the Chamber of Commerce, and Citizens for Responsibility and Ethics in Washington. The ACLU wrote, "The First Amendment does not permit Congress to prohibit corporations from speaking about candidates for office." Are they corporate shills? Myth 8. Citizens United lets billionaires buy elections. The reality is billionaires could already spend practically unlimited amounts on independent expenditures before Citizens United. What changed? Corporations and unions got the same rights individuals already had. And as we've seen, Jeb Bush spent $150 million, got 0 delegates. Bloomberg spent $1 billion and lost. Steyer spent $253 million and lost. Money helps, but it does not guarantee victory. Myth 9. Democrats oppose it, Republicans support it. Reality. Democrats who've benefited from Citizens United: Barack Obama 2012, supported by Priority USA's Action Super PAC. Hillary Clinton, supported by the same Super PAC. Joe Biden, supported by the same Super PAC. Major Democrats donors using Super PACs: Tom Steyer, George Soros, Michael Bloomberg. And there are also Republicans who oppose unlimited spending: Lindsey Graham and many Tea Party conservatives who oppose crony capitalism, quote unquote. This isn't a clean partisan divide. Myth 10. Citizens United destroyed democracy. Reality is democracy involves elections. We still have elections. Voter turnout has increased since 2010. 2008, it was 58.2. In 2012, it was 54.9. In 2016, it was 55.7. In 2020, it was 66.8. and in 2024 it was 64.1. Has there been more spending? Yes. Has there been more negative advertising? Yes. Is democracy destroyed? No, unless your definition of democracy requires silencing political speech 30 days before elections. Let's zoom out and talk about what Citizens United actually means for American democracy, the First Amendment, and the future. First, the First Amendment versus democratic equality. Citizens United exposes a fundamental tension in American political thought. First Amendment absolutism. The government cannot silence speech, even if that speech gives some voices more power than others. Versus democratic equality. Democracy works best when everyone has roughly equal political influence. These two values are in tension. If you prioritize the First Amendment, you get unlimited political spending and some voices louder than others. If you prioritize equality, you get government control over who can speak and when. The Supreme Court chose the First Amendment. Justice Stevens' dissent chose equality. There's no necessarily easy answer, but the court has been consistently, for 100 plus years, said that when in doubt, more speech is better than less speech. From Whitley versus California in 1927, Justice Brandeis said, quote, "If there be time to expose through discussion of the falsehood and fallacies, to avert the evil of the processes of education, the remedy to be applied is more speech, not enforced silence." 2. The slippery slope of speech restrictions. The government's position in Citizens United was, we can ban corporate speech to prevent corruption or the appearance of corruption. But once you accept that principle, where does it stop? Can the government ban labor union speech, nonprofit speech, wealthy individual speech, media corporation speech? Every restriction creates pressure for more restrictions. If ExxonMobil is too powerful, then what about the New York Times? If George Soros can spend $81 million, why can't that be limited too? The court recognized this slippery slope and said no. The government can't restrict speech based on the speaker's identity or wealth. 3. The public choice problem. Here's the cynical take. Politicians love campaign finance law. Why? Because incumbents benefit from restrictions on challengers. If you ban corporate and union spending, who does that hurt? Challengers. Incumbents already have name recognition, free media coverage, franking privileges, free mail, and official social media accounts. Challengers need money to compete. McCain-Feingold makes it harder for challengers to raise money quickly, which protects the incumbents. Citizens United opened up new funding sources for challengers. Guess which group hated that? Incumbents. 4. The international comparison. The US is an outlier in free speech. Almost no other democracy allows unlimited independent expenditures. Canada has strict spending limits on third parties. UK has strict spending limits during elections. Australia caps donations and spending. In Germany, public financing, strict limits on private spending. But the US is also the only free country with the First Amendment that says, Congress shall make no law abridging the freedom of speech. Not Congress shall make some laws, not Congress can make reasonable laws, no law. The absolutism is uniquely American, and the Citizens United is the natural result of taking that text seriously. 5. The reform debate. You don't like Citizens United? What's the alternative? Option 1. Constitutional amendment. You could amend the Constitution to say, Congress shall have the power to regulate campaign spending, including by corporations and unions. Multiple amendments have been proposed. The Democracy for All Amendment, the We the People Amendment, and there have been others. None have passed. Why? Because amending the Constitution requires 2/3 vote in the House and Senate, or 2/3 of state legislatures calling for conventions, then 3/4 of the states to ratify. That's a very high bar, and there's no consensus. Option 2. New legislation. You could pass a law that strengthens disclosure requirements, closes the 501c4 loophole, requires faster reporting to contributions, and bans coordination more aggressively. This wouldn't overturn Citizens United, but would increase transparency. The Disclose Act proposed multiple times and never passed, would require all groups spending over $10,000 to disclose donors, ban spending on corporations but with significant foreign ownership, and require CEOs to appear in ads. I'm the CEO of ExxonMobil and I approve this message. Democrats support it, Republicans oppose it. It's deadlocked. Option 3. Public financing. You could create a robust public financing system where candidates get public funds if they agree to spending limits, small dollar donations are matched by the government, participation is voluntary. New York City has this, but at the federal level, the presidential public financing system collapsed because candidates opted out. Obama 2008, Romney 2012, everybody since. Option 4. Accept it and move on. You could accept that unlimited independent spending is here to stay and focus on better disclosure, media literacy, fact-checking, counterspeech. This is basically the status quo. 5. The long-term trajectory. Where's this heading? One prediction is more challenges to coordination rules. If independent expenditures are protected speech, why can't they coordinate? Expect lawsuits arguing coordination bans are unconstitutional. Prediction 2 would be something along the lines of challenges to contribution limits. Libertarians argue even contribution limits violate the First Amendment. If spending is speech, why isn't giving money to someone else so they can spend it also speech? This hasn't succeeded yet, but it might. Prediction 3. Foreign spending becomes a flashpoint. If the FEC doesn't aggressively enforce the foreign spending ban, I expect major scandals. Prediction 4. AI and deepfakes complicate everything. Citizens United was about money, the next frontier in synthetic media. What happens when a super PAC creates a deepfake video of a candidate saying something they have never said? Current law doesn't clearly cover this. The bottom line is, Citizens United isn't the end of campaign finance law. It's one chapter in an ongoing fight over free speech versus equality, individual liberty versus collective action, transparency versus privacy, and incumbents versus challengers. And we're nowhere close to resolving it. Here's what you should take away from this video, if nothing else. First, read the damn opinion. Seriously, it's free, online. Don't rely on media summaries. Don't rely on politicians. Please don't even rely on myself. Read what the court actually said. Second, Citizens United is probably much narrower than you think. It did exactly 2 things. Struck down bans on corporate union independent expenditures, overruled Austin and part of McConnell. It did not say corporations are people, remove contribution limits, create super PACs, unleash dark money, or allow foreign spending. 3. The decision follows over 100 years of First Amendment precedent. It wasn't 5 justices inventing new law. This was 5 justices applying Buckley, Belletti, and First Amendment principles. You can disagree with those principles, but don't pretend Citizens United came out of nowhere. 4. Both sides use the same tools. Republicans have super PACs, Democrats have super PACs. Corporations spend, unions spend. Sheldon Adelson gave millions, so did George Soros. This isn't one-sided. 5. Money matters, but doesn't control everything. Jeb Bush raised $150 million and lost. Bloomberg spent $1 billion and lost. Money is necessary. It's not sufficient. 6. If you want to reform, be specific. Don't say overturn Citizens United. Say strengthen disclosure requirements. Close the 501c4 loophole. Enforce coordination bans to more aggressively and create public financing. These are actionable. Overturn Citizens United is a slogan, not a policy. 7. The First Amendment is non-negotiable. You can hate unlimited spending. You can think it's bad for democracy. But if your solution is to ban political speech, you're attacking the foundation of the First Amendment. As Justice Kennedy wrote, when government seeks to use its full power, including the criminal law, to command where a person may get his or her information or what distrusted source he or she may not hear, it uses censorship to control thought. This is unlawful. The First Amendment confirms the freedom to think for ourselves. That's the core of the decision. That's why 15 years later, Citizens United is still the law of the land. For 15 years, Citizens United has been the most lied about Supreme Court case in modern American history. Politicians have lied about it to raise money. Activists have lied about it to mobilize protests. Media outlets have lied about it to get clicks. And millions of Americans have believed those lies.